much, and now I'll give the floor to people who wanted to put question. The speakers. Yes, please.
Oh, all the time. Yeah. Okay. Sorry. Oh, is it working? Okay.
Yeah.
Thank you for your question. My answer is I certainly hope so. I mean, a court that does not take responsibility for its case law is something that escapes the definition of a judicial entity. So yes, they take responsibility for their. If you mean if there is an individual responsibility for some of the decisions that were considered finally by the European Court to contravene with the conventional standards, was that the
Yeah.
you have different regimes, disciplinary regime, under which magistrates can answer, can be held accountable for their way of dealing with the file. But I think that, and I'm not a magistrate, so it's not a magistrate perspective. The main issue here, and the way I see responsibility, is to be able to train yourself as quickly as possible, as largely as possible, to make sure that you are in line with the court's case law, that you are at least following its steps. And that's the responsibility to assume that the conventionality control that Professor Guțan was talking about, and the responsibility to make your own decision based on the conventional standards. That is, not to blindly copy the Strasbourg court's findings. Say because the court said that it's the freedom of expression must be construed in a very large manner, then we will never ever accept an action to pay compensation for some offending remarks. That's not the way, just copying the Strasbourg conclusion. Make your own conclusion. That's the responsibility in my view. Make your own conclusion based on the convention and on the European case law.
Thank you, Katrina. Just a small point here on the legal responsibility of judges, because now you might know that the new law which was adopted, and it was a lot of discussion about the disciplinary responsibility of judges, provides some very severe sanction for judges. I think they are one of the most severe in the European systems, and of course they might be pursued for disciplinary reasons in case of errors with massive consequences. So this is something that we don't find we find only maybe in the most difficult regime for judges in the quote unquote like Italy or Spain. And Professor Peters want to put the question now?
Yes, just a short follow-up remark on your exchange from a German constitutional law perspective, because the Görgelü judgment had been mentioned also by question for you. If the court, the normal ordinary Romanian court, exercises this conventionality control, which you say need not be or must not be blind copying of the Strasbourg case law, but fitting into your own system, there still can be, I suppose, a conflict with a judgment of your constitutional court, the interpretation the constitutional court has given to a fundamental right in the Romanian constitution. Although it was said that there is no real normative conflict, the devil can lie in the details and there may be slight divergences. And as you know, the German constitutional court in the Görgelü judgment said that the ordinary courts must only take into account the convention, but only within the confines of the constitution. So what would be your solution here? The good side of the Görgelü judgment is that the German constitutional court said that if the ordinary courts do not justify their non-application of the European Convention, then this can be sanctioned with a constitutional complaint to the Constitutional Court, relying on the parallel fundamental rights as granted by the German Constitution. It's a little bit complicated in the end. I think it's positive, and I would like to ask how you envisage such a constellation here.
Wow. No, I wanted to ask you if you don't want Professor Guțan to answer, because it was Professor Guțan's presentation.
Yeah, no, I didn't see you anymore there. I thought you were still there next to you. Yeah. But both, I think we should both.
Right, I don't think that.
To stand up back because they don't guide people.
In the first place, I don't think that the Romanian Constitutional Court's position is somehow equivalent to the German Constitutional Court's position towards the national courts. So that's why I think a conflict is hardly possible, because national courts in Romania also do not have a guideline drawn by the Constitutional Court. They have sometimes some guidelines drawn by the High Court of Cassation and Justice through those decisions given into a general appeal in the interest of the law. Sometimes, however, the Constitutional Court comes to give guidelines through the application of its erga omnes effect of decisions, even by saying that High Court's decisions are contrary to the constitutions, which is not within its competence given by the Constitution. So you see, it's another type of relationship between these jurisdictions in the first place. So I could not make a comparison right now with the German case. I didn't go into much detail with the Görgelü case, as well as with the British case, which used the same expression, must take into account, which can be analyzed from different perspectives and with different effects. It's a long-term study here, but I think that Romanian national courts still, in the first place, have to assume their role given by the Constitution, and then in the second place by the Constitutional Court's jurisprudence, or in this relationship with the Strasbourg case law.
You going to put, if I can add something, because now I cannot resist, it's the discussion that we had in the Constitutional Court. I'm not quite, I think, in agreement with that, because what we had said in the Constitutional Court, and we had a recent decision, everybody knows, that we had the decision of the Constitutional Court regarding one article of the criminal law for 1.4, but at the same time targeting the label cases, and this was a decision which was a conflict between a decision of a court and a decision of the High Court of Cassation in the what we call this quasi-legislative role of the High Court of Cassation. I don't know how it translates recursul în interesul legii. There are some
Appeal in the interest of the law.
Opinion in the interest of law. So this was and the Constitutional Court said very clearly in this decision that the constitutional law decision have to have priority even on this kind of general statement opinion that were raised by the High Court of Cassation. So I think the feeling among and why we took this decision, which became a little bit controversial at the international, also at the domestic order, because people feel that maybe we can penalize again the label in the press, and the freedom of press was not respected. Because we felt at the time that if we don't clarify our relationship with the High Court of Cassation, and especially with this kind of general opinion, we are going to lose all the authority in the country. So this was, I think, a statement of authority, and I remember that we decided that this decision will be sent especially to the High Court of Cassation, with the way that it is not in our custom, in order to see, how, in order to avoid that in any case the High Court of Cassation will have to take decision against the Constitutional Court. Or maybe we are at the beginning with this process, and now we have another case where we are putting the same problem. If what we are going to do with this general opinion that is not a normal judgment, the general opinion of the High Court of Cassation, and what we said is that normally we don't have, as in Germany, the competence to analyze the decision of the courts, but we have the competence to analyze the norms of this decision, which at the end of the day, it's a kind of very, it was said before I came to the court, so I couldn't dissent of this, but it is the same. At the same time, it is the same, because it's like controlling this kind of decision. But of course, this is a particular case because it's only on this quasi-legislative function of the High Court of Cassation. So I think that we are, with Bianca, we are in
A little bit, in the end, maybe you can clarify me, is Article 414 of the Code of Criminal Procedure constitutional or not? And are insult and libel still criminal or not?
I think
Okay, because
the opinion in the court was very
the
clear.
decision is not
was
clear.
Was not applied. For this decision,
We can discuss it further.
Opinion,
Sorry.
But, yes, I think that most of our decisions are not clear. Now you don't have to quote me.
No.
So because you have, Constantin,
Okay, I leave you the floor here.
Vous pouvez parler.
Le point de départ, c'est la position de la Convention dans le système juridique humain et dans le système juridique allemand. Dans le système juridique allemand, la Convention est évidemment infraconstitutionnelle, et dans le système juridique roumain, grâce à l'action de l'article 1, la Convention est nouvelle constitutionnelle. En fait, en ce moment-là, l'Allemagne est moniste dans son système interne et dualiste en rapport des droits. Nous sommes dualistes, monistes en rapport avec le système international et dualistes dans le système. Le contrôle de la Cour suprême, de la haute Cour, et un contrôle de conventionnalité et à la même valeur est différent parce que le contrôle de constitutionnalité est opposable erga omnes, le contrôle de conventionnalité est un contrôle inter partes, in casu. C'est la différence.
Sauf si fait par la Cour constitutionnelle. Sauf si fait par la Cour constitutionnelle.
Oui, c'est ça.
Voilà. You have a question, Laurence, no?
I have a question for Jan Galea. I was, and it follows from what I've heard this afternoon. You were speaking about the proliferation use of MOUs or so-called MOUs in the posting. Meaning in a way that though they are sort of strange legal animals, they are political animals with some legal features and so on. And you gave, for the reasons for resorting to these instruments, you gave an example of, for example, Romania willing to establish some sort of contacts with China, but also taking into account its international obligations. Now, I have another question, and it's related to domestic considerations. And I'm not only speaking of the Romanian practice, which I don't know much about, but also looking at the practice of the United States and other countries. It seems also that the executive is also willing not to bypass the legislative power quite often. And in negotiating these types of political agreements with some legal effects, it's a way not to go before the parliament. It's a way not to have any discussion with the representatives of the populations and so on. And this is something that I wanted to have your opinion about, because in fact we've been mostly speaking about the role of courts. We've been mostly speaking about the role of courts when looking at the relationship between international law and domestic law. But it seems to me that the legislative power also had a role to play in this context. So I would like to have your opinion on this.
Thank you very much indeed. As doctrine points out, one of the reasons that initially states took into consideration when concluded so-called politically binding documents was confidentiality. I confess that many of such documents they are made public on the website of the Ministry of Foreign Affairs. The legal department took into consideration those documents that may entail some legal effect, and we put them on the website, but they are not published in the official journal. I have to say that as a matter of diplomatic subtlety, sometimes it's useful to conclude a political declaration instead of a treaty. I know some examples in Romania's diplomatic negotiations where first a document was negotiated as a treaty, and then the same document was signed as an action plan implementing a political declaration on the top level. Practically the content was the same. And of course it I consider that the purpose was not exactly to bypass the parliament, because the parliament was duly informed. But there is a signal in the document that is drawn in such a manner. From the other point of view, indeed, if a document is concluded and does entail some legal effect from the point of view of international law without the parliament having been duly consulted or the necessary procedures having been duly accomplished, there might appear a problem. However, I think that the key to this problem is maybe Anthony Ost's theory that they remain political documents with a legal effect. If the president goes on an unilateral statement, assuming some legal obligations, of course, he or she does not consult the parliament, but that statement has a legal effect as a political act.
Yes, please.
My name is Juliana Borghese. I work with Ms. Regular, and we do have to solve such problems, not every day, but from time to time. It's true that nowadays, not only Romania, but some other states do recourse to such documents which are quite difficult to be qualified. Are we making international law or not, concluding such documents? Are they binding under international law, or they are not binding under international law? Or even it is recourse to a clause which is quite tricky, saying that these documents cannot be interpreted as creating rights and obligations under international law. But if it does not create rights and obligations under international law, does it create rights and obligations under private international law?
No.
But the
No.
parties are subjects of international law. It is sometimes quite difficult, and I think this recourse is sometimes made under different legal systems because of the procedure. Legislative prefers to have a simpler, easier procedure, not to treat it as a treaty, because only treaties, conventions under the articles of International Court of Justice are sources of international law, and there is this proliferation of in-between documents which are quite difficult to be qualified. Sometimes they even, the title is Memorandum of Understanding, or even if it is called Declaration, they may have all the elements of a treaty, then they make international law. Sometimes they may be called protocol, but the nature of the obligation that the parties undertake is just so watered, so no substantive, then they cannot say that they are legally binding documents under international law. So, well, I think we still have this dilemma from time to time, and we may ask the distinguished participants if they have some other opinions.
Thank you. And Alice, you wanted to
Yeah, I have an opinion on that. I think in reality we must think of legal effects, of a variety of legal effects short of bindingness. All these documents, they deploy legal effects, and I think the most important is that they serve as a guideline for interpretation of other hard legal texts, and they are, and this is I think in practice very common, they are used as a point of reference for the they are incorporated into other texts through general clauses. For example, what constitutes negligence for a doctor is defined with reference to all kinds of code of conduct, etc., etc. And also in the financial area, what constitutes due diligence or not. And this is for me clearly a legal effect, but a different type of legal effect from bindingness in the sense of creating rights and obligations, pure and simple.
Indeed, it may be a matter of interpretation, and indeed that such documents may have a legal effect of interpreting or serving as a basis of interpretation for, as you said, hard laws. However, I wanted to refer to the particular cases of bilateral documents in which a certain type of commitment conduct is taken without an express possibility for it to be linked to another. Is that commitment just a declaration of intent, or is the state bound both in international law and that may entail some consequences in domestic law? What you say indeed is perfectly true. The interpretation effect of certain documents is absolutely a reality.
Can I have one short follow-up question? Because you cited Professor Klabbers, and if I recall well, his argument was basically that MOUs can be seen as treaties.
Yes.
At the time, it was seen as dangerous because states would then lack a useful instrument for negotiations. So one might think that if states would nonetheless wish to use MOUs, they would state expressly that they are non-binding.
Yes.
But also from your talk, I understand that this is still often ambiguous. So my question is, if you really want it to be non-binding, even though you may recognize legal effects, why not simply state so, rather than leave it to the interpreter, like Klabbers or someone else, who might see a legal nature where there is none intended?
Thank you for your question. This is very important. When the parties agree that such a clause be inserted, it's perfect. This is what I recommend to negotiators. When we have a memorandum of understanding which we want to be a political commitment, insert a clause. This memorandum of understanding does not create rights and obligations under international law. But sometimes it may be in the interest of even of my state to negotiate a document that will be presented as a political document to the other side, but skip some legal effects in it. And indeed, this is a matter of hypothesis, but it may come true.
Victor, please.
Good evening. My name is Victor Stoica. I'm a lawyer in the Bucharest Bar and also PhD candidate at the University of Geneva. Professor Valens Masanders is my supervisor. I have one question. You ended your presentation by saying that the fact that states do not conclude treaties anymore, and there is a tendency for states to conclude memoranda without any legal obligations but with political obligations, and you discussed about bypassing the parliament. In my view, eventually there will be a dispute, and the ICJ resolves legal disputes. Wouldn't you say that by drafting these memoranda with political obligations and not legal obligations, and furthermore, which would arise political disputes and not legal disputes, wouldn't it bypass the competence of the ICJ? And if so, how is this positive? Thank you.
Thank you so much. Indeed, if the parties made clear, like with an express clause in the text, that the document is a political commitment, as for example in the Vienna document on confidence and security building measures, of course the ICJ will not be competent to rule on the basis of that documents. If this is a positive development towards rule of law on the international level, it's difficult to say. On one side, it may be regarded as a dilution of international law, that states tend to conclude some documents which are not law. On the other side, it may be regarded as a positive development in international relations, not exactly in international law, because two options would have been envisaged: no document or this document, because one state would not have agreed to conclude a treaty on that topic, but it might have agreed on having this declaration. So in international relations, sometimes it's more useful to have something than nothing. Thank you.
Thank you. Please.
I also found very fascinating this last presentation by Mr. Miller. So I wanted to, it's not actually a question, it's maybe more of a comment of this, but the way I understood the essence of this presentation, it was not whether these documents are binding between the Mr. Go said already the International Court of Justice has already found that many of these documents are legally binding if they contain provisions of that kind. So, the way in Serbia, for example, the documents, of course, to be part of the international treaties, to be part of the international order, they have to be ratified. So, I would assume that the courts would not accept immediately these type of documents and apply them. However, if one of the parties then involved maybe the practice of the International Court of Justice or International Court of Human Rights, then it is possible that the court would accept that practice and use it as a justification, and I assume that something like that could be done in the
Well, what I wanted to conclude, however, the time was quite short, was that the question of the application of such documents, if they entail legal effect in the domestic law, is open. The issue is so new that it didn't have time to build a jurisprudence. However, I just wanted to signal the fact that in certain cases, like the trade with meat products, they may have an effect in the domestic law, meaning that it creates the possibility for that, the right for that producer to have the export certificate, that in certain future might come in front of the court. Of course, one of the conclusions was that the issue of publicity is an important one. If the document is not published in the official journal, it's I'm skeptical for the fact that in the beginning the court will take it into consideration. But it would not be a it may be a matter of thought for the possibility to envisage a certain matter of publicity of such documents.
Another question.
No, I can just add that from the same pool of 2,000 cases I mentioned, there are dozens and dozens of cases, domestic courts, that do cite to refer to these type of semi-informal instruments. They're never used to limit or determine rights directly, but they're always used in a way that Professor Peters indicated, by way of interpretation of other norms of domestic or international law. So there's a fairly wide practice of doing this.
Thank you. Yeah.
Is there time?
No, it's still time, yes. It's
Yes,
an
I
interesting
wanted to
discussion.
make some remarks on the excellent presentation of Professor Neukemper. I agree that we should look at direct effect or application, what we just spoke about, not as a technical matter, but profoundly as a matter of legitimacy, as we said. The question is, it has been discussed so long as a technical question. Are the norms sufficiently precise? Are they unconditional and so on? But what's really at stake is, as we said, separation of powers, democratic legitimacy and so on within the state. And I think that the courts should not be the gatekeepers. That they are not suited to be the gatekeepers. If the executive negotiates an agreement, if the parliament ratifies that agreement, the two branches have made a decision, and I think it is the normal state of the law to be applied. That's the normal. So as Pescatore said, for EU law, the non-direct effect or the denial of direct effect should be considered as an infant disease, because if law is law, then it's applicable. And therefore, I think we should acknowledge a presumption of applicability, so that it must be the other way around as it has been approached traditionally. That's right.
Well, I mean, I can see this as a normative proposition, but it's quite far removed from the practice we see worldwide. That's one. And even apart from that, a court will have to make major judgment calls. Not so much on substance, but on the question of whether a treaty does or does not protect the rights of private parties.
Yeah.
And then that's really a matter of interpretation, and that has to have a...
Yeah, of course. It is a manual, right? Of course, the court must interpret, but they should not start. I think in traditional views that there is a kind of presumption against the direct effect, and that should be reversed. And the new issue is also very much questions of obligation conditio to identify an obligation, which is even sanctioned by criminal liability of an individual.
Yes, and this is very rare. But the very strange thing is that in the international criminal courts, you find it perfectly normal that customary law is used to determine individual responsibility.
I think it's a huge problem.
Whereas in domestic courts, it's considered to be not done. It would be violating the principle of legality. So it's a very odd, it's a schizophrenic situation.
And I think it's still an upcoming issue.
Yes. Bogdan, please. You have a question? You have a
but
comment?
maybe a comment on
You have a comment? No? So nobody wants to comment or to put questions anymore? So maybe Laurence would like to
Okay,
conclude.
so after Andre counted the number of presentations, and we have achieved a marathon. We've done it. Spent the afternoon in this beautiful room to discuss about a theme of great importance for Romania, but also for other countries in the world. And this is something which is interesting and important also, I think also from the perspective of the European Society of International Law, that the sharing of experiences and the sharing of knowledge is very important among lawyers, and the European Society wants to be a network where you can have exchanges and discussions, scientific discussion. So I would like to thank you for having come. I would like to thank Professor Motok for having organized this meeting, and I would like lastly to encourage you to become members of the European Society of International Law. As I said, there are quite diverse events which are going to take place organized by interest groups of the European Society, but the next big event is going to be in Vienna in September 2014, and it's going to be on a topic of great interest to a lot of us, so it would be wonderful to see you again in Vienna in 2014. Thank you very much.
Je veux remercier, parce que la société européenne a des langues, je veux remercier d'abord à notre hôte qui vient de la Société européenne de droit international, aussi aux panélistes, aussi aux panélistes, aussi aux gens, tous les participants à la conférence. Et je voulais aussi, je pense qu'on a eu une très intéressante discussion ici sur ce sujet. Et je pense qu'on aura plus de gens qui nous ont écoutés à travers le site JURIDICE.RO qui a enregistré et transmis en direct cette conférence. Et j'espère que beaucoup de nos participants et aussi des gens qui nous ont écoutés dans le pays ou même à Bucarest vont devenir membres de la Société européenne du droit international et vont suivre nos débats. Et il ne faut pas oublier le fait qu'on va publier ces débats que je trouvais, même moi-même qu'à un certain moment j'avais marre de tellement de conférences, je trouvais très intéressant, je dois dire. Et merci beaucoup. Et je dois avouer que je me trouve toujours en étant internationaliste et pas un conservatrice. Merci beaucoup. Merci beaucoup à tout le monde. Ok.
Thank you. I want to give my thanks, and I think everybody's thanks for having invited us here, and me especially among friends I have met after a long time. Thank you, Julia. Thank you, the European Society, and especially for Julia, best of luck. Thank you.
Merci beaucoup, Bianca.